Hey guys, I'm Todd King with the Accident Recovery Team. For those of you that may have been following, I'll refer you back to a video we did in September where I gave you an update about the Johnson case. To give you a short review, the law used to be that your impairment rating, that number assigned to you to determine the extent of physical injury that you've suffered, was under the 4th edition of the AMA guides. The law changed in 2013 to say, hey, we're going to start using the 6th edition. There was a challenge to that went to the Kansas Court of Appeals and ultimately the Supreme Court. The challenge was that the 6th edition produced such a low number that it wasn't fair anymore. There was this trade-off that you didn't have to prove fault in the work comp system, but there was a cap on how much you could win. There's caps on the amount of damages you can win. Well, that exchange is no longer fair if you keep eroding away what you can get, even though you didn't have to prove fault, but the exchange of the cap keeps coming down. It's not fair anymore. That was essentially the argument to the Court of Appeals, and they said, yeah, you're right. The 6th edition, not fair anymore. So they said, we're going to go back to the 4th edition. That was appealed to the Kansas Supreme Court. While it's on appeal, we're still stuck with the 6th edition. The update I gave you in September was that issue had gone to oral arguments before the Kansas Supreme Court. I told you at that time I would keep you posted and it would take a few months. Well, here we are. It has taken several months. We now have the decision from the Kansas Supreme Court. I'll remind you, the question was, are we going to use the 4th edition or the 6th edition? Not uncommon, we were surprised by the Kansas Supreme Court, who ended up saying, you guys are all reading this wrong. It's not the 4th, it's not the 6th, it's substantial competent medical evidence. They go on to say that the 6th does constitute competent medical evidence upon which an opinion can be based by a doctor, but it's not the only source. It's the basis, it's the starting point, which means now we may have a floodgate of cases that are going to be litigated to flesh out what exactly that might mean, right? So if the Supreme Court is saying you can have another source besides the 6th, but start there, that means now that the doctor is free to look at the 6th edition book and say, this particular person's impairment rating is not fully explained within the 6th edition. I'm going to deviate from the 6th edition and go to some other source. I can look to the 5th edition, the 4th edition, the 3rd edition. Maybe not even use the AMA guides to impairment. It now comes down to the doctor essentially being able to simply support his opinion of impairment rating, but the starting point is the 6th, but we're no longer mandated or bound by the confinements of the 6th edition only. So it means we're starting to look a little bit more like Missouri's law or some other states. Some of the defense attorneys that I argue against are taking a different interpretation. Some of them aren't. They agree with me. But the court's now going to have to tell me if I'm right in this interpretation or not. But I think that's where we're headed. I think now it's not just the 6th. That's the starting point. If the doctor can explain an impairment rating on why he went beyond or outside of the 6th edition, that's going to be accepted. I think what we're looking at now is the court's going to be looking at multiple opinions from different doctors, probably giving them equal weight and averaging this out. It's going to take us a while to figure it out, but the decision is in. It's not necessarily a negative opinion. It's an unusual opinion. I'll keep you posted on how this is going to play out. Thanks, guys. Bye-bye.